CR1 is now in session.
Please be seated. We're here today in 1 CV130737, Con rebates. Each side will have 20 minutes to make their arguments. Appellant, you're entitled to reserve any portion of the time for rebuttal, but you'll have to keep track of your own time. We have a clock at the podium for that purpose. We are recording the argument today, both audio and video. So in a couple of days, it will be on our YouTube channel, so you may be YouTube stars. We have read the briefs, we've conferenced the case, and so when you begin your argument, just launch right in. And I always forget to say this, because we are recording the argument. When you begin your argument, please identify yourself and the party you're representing. Appellant, you may begin.
May it please the court. My name is Brian Imbornoni. I represent Dr. and Mrs. James Bates and Tri-State Surgical Associates, PLLC. The court should reverse the judgment awarding damages to Dr. Khan for his partnership interest in Tri-State, should enter judgment for Tri-State on its counterclaims, and the court should deny the cross appeal. And I will address those points in that order. The trial court's decision that Dr. Khan acquired a partnership or other ownership interest in Tri-State is not supported by substantial evidence and is wrong as a matter of law. First, Dr. Khan did not acquire a membership interest in Tri-State.
Counsel, before you discuss that, is the judgment here a final judgment? Did it encompass all of the claims here?
Yes, Your Honor. The judgment is a final judgment. The trial court found, following the partnership accounting, that the special master proceeding and accounting was a full and final disposition of all monetary claims of the parties, and made the, excuse me?
Well, but because how does an accounting of who owes what under any partnership arrangement, how does that resolve the breach of contract claims or the other claims?
The your question, Your Honor, relates to the cross appeal, claiming that there should be further proceedings in the trial court in the wake of the special master proceeding. The court has determined that all of the claims in the case have been adjudicated. That decision is a matter of trial management and a matter of discovery, and is reviewed for an abuse of discretion. The issues in the cross appeal came to be framed by the way that the plaintiffs prosecuted their case. Basically, the plaintiffs did nothing for 2 years. The disclosure statement was simply a recast of the complaint. The plaintiffs took no depositions, took no discovery, and most significantly failed to disclose any damages whatsoever. This is not a case where the plaintiffs were somehow ambushed, as was suggested below. When we received no damage a disclosure. We sent letters. We sent interrogatories. We took Dr. Kahn's deposition. We even filed a motion for summary judgment on damages.
Those may be all good reasons that some of the claims should ultimately fail. But here the trial court just seemed to lump them all into one decision without any reference to the procedural history that you've mentioned, without any reference to their elements. Can that be sustained?
Yes, Your Honor. On the eve of trial, we filed a motion in limine on the grounds that the plaintiffs failed to disclose any damages. The plaintiffs moved for trial continuance for medical reasons, then used the time to regroup, asked for the case to be bifurcated, responded to our motion in limine saying they are only seeking damages in the context of a partnership accounting. So the court denied the motion in limine, bifurcated the case for the partnership trial, sent the case off to an accounting. When we came back to the trial court, the judge adopted the accounting as a full and complete determination of the claims of the parties, and the court, I believe that decision can be sustained on three independent grounds. The first is judicial estoppel. We got to trial, we filed the motion in limine, plaintiffs are here with no damages, and the plaintiffs told the trial judge, we're only seeking damages in the context of an accounting.
So you're claiming essentially that they simply waived all other causes of action?
Yes, Your Honor. They are stopped from now seeking to pursue damage claims that they told the court did not exist, to avoid the consequences of a motion in limine, to obtain, to salvage their case in a partnership accounting.
Wouldn't the appropriate judgment then have been one dismissing all the other claims rather than simply aggregating them?
Well, I believe that the judgment in the case makes an express finding that all the claims that were brought by the plaintiffs have been resolved. So I believe that express finding in the judgment has the same effect. The second reason why the court's order adopting the special master report as a full and complete resolution of the parties' claims is, again, because the plaintiffs failed to disclose any damages whatsoever. In opposition to the motion to adopt the special master report as a complete adjudication, the plaintiffs basically accepted that they had never disclosed any damage claim to go to trial. What they asked is that the court reopen discovery 2 years after discovery was closed. The plaintiffs gave no good reason for that, and it was within the discretion of the trial court to deny the plaintiffs the opportunity to reopen discovery and to try to prove more damages. So what we have is the plaintiffs elected to proceed exclusively on their partnership claim, and they salvaged their case by doing so. You know, the partnership accounting is a historic equitable remedy that predates discovery. So under the accounting, the traditional accounting remedy, you would have to make the showing of the existence of the partnership and the entitlement to the accounting in order to get the records sent for the accounting. Here, the plaintiffs failed to make any cause of action, to show any cause of action for damages, and then they used the accounting remedy to salvage their case on the eve of trial. So, well, okay, we never showed a cause of action for damages. We never developed our case. We never made the disclosure required by the rule. But here we are. We're entitled to go to the special master and present a damage claim after the close of discovery at that time. And that's exactly what happened. When we came back to the trial court, we're still faced with the same situation we had when we filed the motion in limine. There was no evidence of damages. There was nothing left to try. And the judge's decision that the plaintiffs had no remaining claims to try is also supported by the nature of the activity in the accounting. The plaintiffs were afforded an opportunity in the accounting to raise any theory of recovery, any damage theory that they wanted. And for a period of 14 months, the plaintiffs made allegations of wrongdoing and misdeeds by Dr. Bates and Tri-State, and in each case, the special master, with Tri-State paying half the expense, would get more documents and investigate for the plaintiffs and determine that there were no improprieties. So the trial court did not abuse its discretion in finding that there was a full and complete resolution of the claims because the plaintiffs told them they were only seeking damages in the accounting. The plaintiffs never disclosed any damages, so we had no remaining causes of action to try. And the plaintiffs conceded as much by telling the court in opposition to our motion to adopt the accounting as a full and complete accounting of the claims of the parties I'm sorry, I lost my train of thought, but the court was within its discretion.
I think you've answered that.
Okay, thank you. Returning to the partnership issue, Dr. Khan did not acquire a membership interest in Tri-State. The Limited Liability Company Act requires has specific requirements for acquiring a membership interest in an LLC, including compliance with the operating agreement. Here, the operating agreement required an amended operating agreement, a written undertaking by the new member. The Limited Liability Company Act also required the filing of articles, amended articles of organization for any member who would be acquiring more than 20%. Now, the plaintiffs suggest that these requirements of the LLC Act can be waived or disregarded. In fact, there is a public policy interest. The LLC form has a corporate shield, and the statutes require a disclosure of who the members are behind the shield if any member owns more than 20%.
Well, that's true for the shield, but what if an LLC enters into a joint venture outside the shield?
Yes, Your Honor. The plaintiff did not acquire a membership interest. The plaintiffs argue instead, or in the alternative, that there was some kind of partnership, either a partnership interest in the LLC, which is a non sequitur, or a partnership agreement with the LLC. And both of those are contrary to law and are not supported by substantial evidence. And we believe...
Well, why is that? I mean, why is it contrary to law? An LLC can be a general partner in a general partnership.
Well, it's as far as the legal proposition, we submit the case is controlled by this court's recent decision in Vortex versus Denkowitz. The case had very similar facts. The plaintiffs were conducting business as employees of a corporation with written employment agreements. The plaintiffs failed to follow through on a proposal to restructure the business with them being members as an LLC, and then the plaintiffs sued, alleging that there was a partnership. The court held that the partnership formation statute 29-1012A does not apply where the plaintiffs were hired as employees. The parties contemplated restructuring their business in a form that was not going to be a partnership. Here, the parties were negotiating for the purchase and sale of an interest in an LLC. It's clear, it's admitted. Dr. Khan was hired as an employee of Tri-State under written employment contract, and the parties entered into negotiations for the purchase of a membership interest. It's admitted by everyone that forms of membership agreement were exchanged, but in the end, Dr. Kahn was not willing to accept the was not willing to close the transaction for the purchase and sale of a membership interest. The court cited comments from the Revised Uniform Partnership Act, which state that a partnership is a residual form of business entity existing only if another form of entity does not. And applying that to the Dankowitz case, the court found that where the parties had employment agreements and were negotiating for the purchase and sale of a membership interest, you couldn't invoke partnership as a residual theory. There's also insufficient or a lack of substantial evidence of intent. Now, the statutes don't require intent to invoke the partnership form, but the statutes require intent to carry on as co-owners of a business for profit. That didn't happen here. The concept of a partnership with Tri-State, between Tri-State and Dr. Kahn, was invented late in the case. Early on, they were arguing that they had a membership interest or that they had a partnership interest in an LLC, and later argued that somehow at trial, just before trial, they argued for the first time that there was a partnership with the LLC. But this alleged partnership, by Dr. Kahn's own testimony, it had no name, no assets, no financial records, no existence independent of the limited liability company. It had no provider contracts. It had no revenues. The accountant and the business advisor, who were both dealing with this company, were never aware of the existence of this partnership, and apparently neither was Dr. Kahn until just before trial, when he realized that there were problems with his theory that he acquired a membership interest without complying with corporate formalities, or acquired a partnership interest in an LLC, which is a legal non sequitur. Dr. Kahn relies on use of the word partner to create an estoppel. There's a line of Arizona cases holding that estoppel does not, a partnership by estoppel does not apply between partners. That's only a concept applicable to third-party dealings. I see I'm running quite a bit behind on time. I'll reserve the rest of my time for rebuttal.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Tashura Ann Elias. I represent Dr. Kahn and Mrs. Kahn, the plaintiffs, the appellees, and the cross-appellants in this case. This matter, which was initiated back in 2008, has seen 7 years of litigation, and the trial court made numerous findings of facts and conclusions of law on the issue of the existence of a partnership between the parties, all of which are both material to the resolution of this matter and factually supportable to the finding that Dr. Kahn and Dr. Bates, through his entity, entered into a verbal partnership agreement between February 1st, 2006 and January 31st of 2008, and that they both conducted themselves as partners during this time frame. Partnership is a contractual relationship.
Partnership between Dr. Kahn and Dr. Bates, or between the entity and Dr. Kahn? Who are the partners in this partnership?
The partners in this case would be Dr. Kahn and Tri-State through Dr. Bates. Dr. Bates is the only member of Tri-State Surgical.
Okay. So you're taking the joint venture theory then, that an entity decided to create a partnership without following corporate formalities, without allowing a member in, an entity through its agent simply became a partner to a general partnership. Is that the theory?
Based on the facts in this case, that seems to be what happened between the parties. There's nothing under the law that prevents an entity from entering into a partnership with a person. There's nothing that requires, in this instance, the LLC statutes don't apply. It's a situation where, yes, there was an operating agreement that governed Tri-State, but for purposes of Dr. Kahn and Dr. Bates and what they intended to do in the future, after they entered into the employment agreement, which was outlined in paragraph 14 that was cited quite frequently by the parties throughout the litigation and in the briefs, was to have a discussion about an equity participation. And that's not defined. And those are terms that came up from Dr. Bates and Tri-State when they assumed the employment contract once they were formed after the employment agreement was entered into.
They weren't trying. Your client wasn't trying to become a member of the LLC. You were outside of that, and that's what was intended. Outside of the LLC?
I believe what was originally intended, Judge Howe, was that the partners in end of 2005 had negotiations and discussions about entering into a verbal partnership where Dr. Kahn would receive 49% interest and Tri-State and or Dr. Bates would receive 51% interest in sharing of profits, expenses, and the like. There was discussions about a subsequent agreement to memorialize this transaction entered into, and they did discuss an operating agreement, but that doesn't change the fact that an oral partnership was actually formed and they conducted themselves accordingly under those terms for a period of time.
What did Tri-State give up in forming this partnership? I mean, I understand that an LLC and an individual can form a partnership to engage in a new venture. But it sounds to me like you're saying that this new venture involved Tri-State giving up essentially half of itself in exchange for what? I mean, if Dr. Kahn acquired a membership interest, that would be easy to understand. But it sounds as though Tri-State didn't simply become a partner in a new venture, but it diminished itself for the benefit of another. Is that your theory?
No, that's not my theory at all. Dr. Kahn and Dr. Bates, when they entered into negotiations, what Tri-State would be receiving is Dr. Kahn's buy-in. Dr. Kahn was going to buy in and pay
$20,000?
That's correct. $120,000 buy-in, payments over a period of 3 years, be effectuated over by book transfers, and the parties also agreed that they could use Dr. Kahn's outstanding accounts receivable as of February 1st, 2006, and that would be the buy-in plus 49% of the hard assets. Those are the terms for which this partnership was going to be created. There is the argument by the appellees in this case that somehow Dr. Kahn did not acquire a membership interest because they never followed the operating agreement. And as argued in our briefs and what has been argued throughout the case is that the operating agreement applies to Tri-State. The operating agreement applies to Dr. Bates. If Dr. Bates was required to do something under that operating agreement, then that is his duty to do so. You can't really interpret the operating agreement as it relates to Dr. Kahn's employment agreement because it was never mentioned in the employment agreement.
You can apply it to Tri-State, right? I mean, if two people meet at a party and one person gives another $1 and they agree jovially that there's now a membership interest in an LLC, that doesn't get the job done, does it?
In that instance, no.
Okay, but in this instance, you have a more substantial economic transaction. You have a meaningful intent to do business together, presumably, but you don't have a membership interest created or conveyed in the LLC at all. So it sounds like and would you agree with that? I mean, is there a membership agreement or a membership interest or not?
No, there is no membership interest in the LLC because the operating agreements were never signed.
So how do we then hold that one can have the same beneficial interest in an LLC as a member without following the statutes or operating agreements, without robbing those the law and all of those agreements of their force?
I think this is a situation that clearly falls under Oaxaca Sheep Company versus Heirs of Oaxaca, where the Court of Appeals specifically said that it's not unheard of for individuals to have a corporate form and a label attached to, whether it's member or stockholder or shareholder, and still conduct themselves as partners in that instance. And that's exactly what happened here, is that we do have a corporate entity, we do have a corporate form. But before that membership interest or whatever it was supposed to be was actually formalized, these two people, these two parties, for a long period of time did conduct themselves as partners after entering into the verbal partnership agreement. And if there was something else that needed to be done to memorialize it, it doesn't change the fact that there is an oral partnership that is enforceable because the parties intended to conduct themselves that way during this time period.
How did they handle taxes during this period?
During this period, according to the testimony from the CPA, Mr. Johnson, once he was informed by Dr. Bates and directed that, Dr. Khan is going to be a 49% interest holder in with respect to splitting profits, he set up two equity accounts. And then what happened according to the facts of this case, is in January of 2006. Mr. Johnson informed Dr. Bates that there would be a tax liability and Dr. Khan had to pay estimated taxes. So that's what he did, and they provided the forms to do so.
But did Tri-State issue a K-1?
There was a draft K-1 that was issued to Dr. Khan from Tri-State.
Draft K-1. How do you issue a draft K-1?
Well, it was considered a draft because Dr. Khan and Dr. Bates hadn't formally entered into a memorialized writing regarding the terms of the partnership agreement.
Okay. But the K-1 then was issued by Tri-State, or the draft K-1 was to be issued by Tri-State?
Yes.
Even though Dr. Khan wasn't a member?
It's still a form that identifies a partnership interest or an interest in an entity.
Well, the partnership would then have to issue its own K-1s if there's a separate partnership. But for an LLC to start issuing K-1s to non-members seems like a practice that's pretty far away from anything that either the tax laws or the corporate laws contemplate.
Except that the CPA, Mr. Johnson, had testified at trial that he issued forms 1040-ES to Dr. Khan for the payment of estimated taxes, and the reason he did that was because Dr. Khan was a partner. He also
1040s are individual taxes. I'm talking about pass-through entity reporting forms.
And the testimony was that there were these draft K-1s that were prepared. They weren't necessarily sent out because the parties hadn't had a memorialized agreement, written agreement regarding.
Sent out, were they filed?
I don't believe that they were filed. I believe the parties had requested extensions on their tax returns so that they can deal with the issue of the writing and the actual written agreement, which wasn't signed by Dr. Khan because it had substantially changed the terms of the agreement for which they were already operating under the verbal agreement. It was substantially different. And those are the reasons why he didn't actually enter into the written draft. And even though the parties had decided to memorialize the agreement, the verbal agreement, into a writing later on, it still doesn't change the fact that there was a binding oral agreement that was enforced by the parties. There was intent to be bound by that agreement, and they conducted themselves accordingly from February 1st, 2006 to the time that Dr. Khan was terminated as partners. It's more than a word. It's more than a title that was given to Dr. Khan. He had Dr. Bates referred to him to the public as a partner. He referred to him in newspaper articles as a partner. He involved him in business decisions. He referred to him as other employees as a partner. He referred to him as a partner to the CPA and directed him to do certain things that you do with respect to a partner, like creating equity accounts and capital accounts and dividing up the profits according to their membership interest or their interest in the partnership, 49% for Dr. Kahn, 51% for Dr. Bates. He also, with respect, there was another doctor that was employed during this time frame named Dr. Bailey, and at his deposition, he specifically said during his interview and during the time of his employment, Dr. Bates referred to Dr. Kahn as his partner, and Dr. Bailey felt that Dr. Kahn, as a partner, had authority over him. All of the conduct.
There's a big difference, though, between holding someone out as a partner and giving them an equity interest in a business. I think you could look to any number of law firms within throwing distance of this building and find that practice to be the case. Right? I mean, there are people who are employed who receive incentives, who receive profit sharing, who receive the title of partner, but who are fundamentally employees with complex compensation schemes, not equity owners. And isn't that the difference we're talking about here?
Well, I guess that would depend, Your Honor, on what Dr. Bates meant by equity participation, and there's no definition in the employment agreement as to what he meant. There is actually no definition that was provided at trial. There's no reference as a member or a limited liability company in the employment agreement. And to further answer your question, based on the facts of this case, after the employment agreement was entered into and several years after they were operating under the employment agreement, the parties got together and they entered into a subsequent agreement which dealt with this partnership interest, this 49%, 51% division and partnership. They also increased their salaries. They also agreed to bonuses. They also agreed that Dr. Kahn would have to give something in consideration for being a partner, and that was his buy-in, the $120,000. So it wasn't just a word, a colloquial term that was used with respect to partner. There was something more that was done, and the partners and the parties that were involved in this verbal agreement actually conducted themselves according to that verbal partnership agreement.
Counsel, if a person negotiates to become a member of an LLC and they work together, if that negotiation falls through, is there a residual partnership that exists anyway?
If the
and the second part of my question is that what we have here?
I don't believe that's what we have here. I believe what we have here is a verbal partnership agreement. I don't see anywhere while the parties had actually intended to enter into a writing, memorializing the terms of the agreement, at that point in time and at the time that is the issue of this case, they conducted themselves under a verbal partnership agreement. With respect to your question, Judge Howe, I think your question would depend on what the parties did in terms, did they have a membership agreement? Did they have an operating agreement that controlled them? Because if they had those things, then the outcome would be different. You'd be controlled under the LLC statutes and you'd be controlled by that operating agreement. Here we don't have an operating agreement at all that involves Dr. Kahn. We have just the verbal agreement between the parties that was supposed to be memorialized at a later date and just never was.
So it seems like the fundamental proposition then in your argument is that the corporate form of Tri-State should simply be disregarded. This is basically a veil-piercing argument, and we should look at Dr. Bates and Dr. Kahn as forming a partnership without any reference to Tri-State.
No, I believe that the corporate form of Tri-State doesn't get disregarded. I believe that the entity Tri-State, as a person defined under the statutes, entered into a verbal partnership agreement through its agent, Dr. Bates, who happened to be the only member of the entity. that's what happened. We're not disregarding the corporate form of Tri-State. We have an entity acting as a person entering into a partnership agreement with an individual. I think if it would probably be different in these circumstances if we actually were dealing with a multi-member entity. We're not. We're dealing with a single member entity that is got a corporate form that we're not disregarding. We're just saying that you're entering.
Figure that out. I mean, what if we were dealing with a multi-member entity? What if Tri-State had 25 members? What then? Does this work?
It would depend on the circumstances. I think it would depend on whether or not there's an operating agreement in place that...
Let's say it's Dr. Bates, leaving aside professional licensing considerations, if Dr. Bates, 24 silent partners who fund the operation, and Dr. Khan.
Mm-hmm.
Now, if this theory were played out in that situation, I imagine it would be much harder to argue that Tri-State gave up 49% of something when the other holders of membership interests had no say and their rights under the operating agreement weren't complied with, right?
If all of the parties agreed to the terms and they manifested an assent to the agreement of the terms and they conducted themselves accordingly...
What if they didn't know?
Then that would be a completely different situation if they didn't know.
Right. So that would be a completely different situation if you have other members who don't know, because then we would suddenly say, wait a second, these corporate formalities are really important. Here we're saying these corporate formalities aren't important, and so I'm struggling to find why you maintain that this isn't simply a veil-piercing theory.
Because for purposes of what happened, the corporate veil wasn't pierced. It was Dr. Bates acting on behalf of his company. And so that's the situation with respect to this. The LLC statutes, while applicable to the entity itself, Tri-State, for purposes of finding a partnership, it's going to be treated differently. You can't have a business who is organized under a different statute say it's a partnership. So an LLC that's organized under the LLC statutes involving its members and conducting themselves under the LLC statutes and an operating agreement, for purposes of that, it's not going to be considered a partnership. But we don't have that same structure in this particular instance. We have a single member entity deciding to act openly, deciding to enter into a partnership with an employee and following through and conducting itself as partners.
That sounds like an alter ego theory, doesn't it?
To a certain extent, it does, but at the same time, it doesn't mean that the parties who are involved or the entity itself, like I said before in Oaxaca, the entity itself and the parties can kind of disregard their corporate form, still keep it, but still act as partners within it when they conduct businesses. And that's what the court in Oaxaca had found, is that, yes, they're members of an LLC, but they actually conducted themselves as partners.
Counsel, we will add 2 minutes to both sides' arguments, but I wonder...
Can I vote on that? No, I'm just teasing you. Go ahead.
Thank you.
But, no, please, please add 2 minutes to both sides. A question I have is about the cross appeal. I mean, the argument, as I understand it, is that your client has waived those other claims as long as you persevere on the partnership claim. Is that correct?
No, that's not correct. And I think one element that was missing in the procedural history of this case is that in addition to the motion in limine, which actually just dealt with the issue of preclusion of damages, there was a motion to bifurcate the claims and have the court determine the issue of whether or not there's a partnership first and then an accounting afterwards, because you can't get to the other claims, whether it's breach of fiduciary duty, breach of contract, fraud, or the like, disassociation of the partnership, without a finding by the court that there was, in fact, a partnership. And the court, in its order, bifurcated the claims and said, yes, the issue of whether or not there's a partnership is a threshold issue that you have to figure out first before you can get to all of the other claims. There wasn't a waiver in the motion to bifurcate. There wasn't a waiver in the response to the motion in limine. There was a situation where the court actually reserved jurisdiction in its findings and facts and conclusions of law to deal with the other issues after the accounting was completed. So it was never waived, and it's never been adjudicated. There is no motion to dismiss, no motion for summary judgment on these issues. The court just simply took the special master's report as a final accounting of all damages and said this is done, when the special master's report did not even touch on those issues at all. Thank you.
On the cross appeal, we filed a motion to adopt the special master's report as a full and complete accounting of the monetary damage claims of the parties, citing judicial estoppel, citing the fact that there was no disclosure of damages, so there was nothing left to try, and based upon the comprehensive nature of the accounting that was performed, the court set a due process hearing and heard the issue of whether there was anything left to try, whether the plaintiffs were precluded from seeking more damages by their failure to disclose any damages prior to the end of discovery. In response to the motion to adopt the special master decision as a full adjudication of all the claims, the plaintiffs in effect conceded they had no damage claims to bring back to trial. They asked the court to reopen discovery. The court was not going to reopen discovery 2 years after the fact to give them another bite at the apple. On the partnership issue, as counsel mentioned, partnership is a matter of contract. There must be an agreement on all material terms. And Judge Swan, you asked, who are the partners? That's the same question the trial judge asked during their closing argument after 3 days of trial, because it's been a moving target. They alleged that there was a membership interest. Then they alleged that Dr. Khan was a partner in the LLC. Then they finally alleged that there was a partnership with the LLC. There was no agreement on all material terms when the parties, when we don't even know the nature of the ownership interest that is being claimed.
Well, what did Dr. Khan get, in your view?
Well, what Dr. Khan got is he earned 50% of what Dr. Bates did during the time of the so-called partnership.
But he got no equity of any sort, in your view?
Correct.
Well, what was the buy-in for?
He never paid a buy-in.
What was it supposed to be for?
Dr. Bates offered him the opportunity to buy a membership interest in the LLC, and he could never agree. He could never agree to close. He could never agree to go forward. The parties, everything that happened in the case was consistent with Dr. Khan being an employee, the parties negotiating the sale of a membership interest in Tri-State, and Dr. Khan not being willing to go forward and close.
Counsel, what about the two advances, though? That's for $80,000, and you wanted an offset for that, right? Wasn't that for the buy-in, in part?
Dr. Khan was loaned $60,000 to pay estimated taxes under the belief that the...
That's not what I asked you. I asked you, was any of that $80,000 part of the buy-in? Was it advance to pay for part of the buy-in? No,
Your Honor. The $20,000 was an advance on his bonus. The $60,000 was an advance to pay taxes made on the assumption that the sale would close. There never was a partnership agreement. This was created after the fact, and that appears from Exhibit 25, which is a letter that Dr. Khan wrote to his accountant in August of 2007, and he said the operating agreement to define this partnership as an LLC with myself and Dr. Bates as members is currently in the process of being negotiated. Dr. Kahn told his accountant, this crossed in the mail with the Tri-State's withdrawal of the offer to sell the membership interest, which had been outstanding for a year. He told his accountant that the partnership was in fact an LLC. The word partner is being used loosely here. The partnership was in fact an LLC, and it was still in the process of being negotiated out of Dr. Kahn's mouth to his accountant. In this case, by arguing after the fact that there was a partnership, Dr. Kahn never assumed any of the risks of operating this business, and having brought in less than half the revenue of Dr. Bates, now receives a 50% profit interest for this period of time. As far as the tax treatment, there was the alleged partnership with the LLC was an invention. It had no physical existence. There were no financial records. There certainly was no tax treatment of it. In anticipation of selling the membership interest in the LLC, there was tax planning, and there was a draft K-1 with draft stamped on it. This is what this will look like when we close. This was tax planning in anticipation of the sale of a membership interest. So no K-1 was ever issued by Tri-State to Dr. Kahn as a member. Certainly no K-1 was issued by the theoretical partnership with the LLC, because it had no physical existence. It wasn't even mentioned until as a theory until substantially later, years after the relationship between these two individuals ceased. So we submit that the judgment finding a partnership should be reversed, that the $80,000 in loans, which were found to be owed by the special master and which the plaintiffs never objected to, should be awarded as a judgment to Tri-State, and the cross appeal should be dismissed because the court properly exercised its discretion to find that there were no remaining claims based on judicial estoppel and based upon the complete accounting. I see I'm out of time.
Thank you, counsel. Thank you for your argument today. We'll take this matter under advisement and issue a decision in due course. Thank you. We stand adjourned.